Usually, when you sit down with friends to play a complicated board game, there is this fundamental expectation of cooperation.
Right. Yeah. You play by the rules.
Exactly. You roll the dice, you move your piece, you pass the board, and everyone just, respects whose turn it is.
But the U.S. Constitution is absolutely not a cooperative game.
No, no, it's not. It is a game where all the players are actively reaching across the table, grabbing each other's pieces, and insisting it's still their turn.
Yeah, it is the absolute definition of designed institutional friction.
Yeah.
I mean, the system just wasn't built for harmony. It was built for a very specific, a very intentional kind of warfare.
Which brings us to today's deep dive. We are pulling from a stack of materials that generally strike fear into the hearts of law students.
Oh, definitely. The bar prep materials.
Right. We've got the MBE Student's Guide to Legal Mastery and a really highly specialized Constitutional Law Masterclass script. It's the stuff they use to prep for the multi-state bar exam.
And if you're listening to this and panicking about, dry, dusty political theory, don't worry.
Please don't panic, because our mission today is to essentially extract the ultimate legal cheat code from these intense bar prep materials.
Yeah, we want to give you a practical, like a pattern recognition framework.
Yes.
So you can instantly decode how the U.S. government actually functions and dysfunctions when the branches collide.
Because they collide constantly. I mean, it's all over the news every single day.
Constantly.
Yeah.
And to understand the chaos you see in the news, you have to understand the baseline structure first.
Right. The stuff we all kind of learned in grade school.
Exactly. Congress legislates, they write the laws, the president executes those laws, and the courts decide the cases. That's the basic board we are playing on.
But the master key that solves almost every single constitutional fight, it really comes down to one simple question. Is the branch in question checking another branch, or are they usurping another branch's core function?
Yes. That is the golden rule right there. Checking is allowed, usurping is forbidden.
So checking means you are pushing back or overseeing.
Right. And usurping means you are actually trying to do someone else's job.
Yeah.
And the most common place we see this line get blurred, it starts the literal second Congress passes a new law.
Because they can't let it go.
No, they really can't. Once a law is passed, Congress almost always suffers from this kind of separation anxiety. They want to hold on to the power to enforce it themselves.
I think of this like a kitchen rivalry. It's the difference between writing a recipe and actually cooking the meal.
Oh, I like that.
Right. So Congress writes the recipe. They decide what the dish is going to be. They list the ingredients, and they determine exactly how much money the kitchen is allowed to spend to buy those ingredients.
And that is valid oversight. Congress has enormous, completely constitutional tools to check the executive branch's kitchen, keeping with your analogy.
Okay, so what does that look like in practice?
They can conduct investigations, they can hold these exhaustive hearings, they can request massive reports from agencies, and most importantly, they can condition funding.
So if Congress wants to drag the Secretary of Defense in to testify for, 8 hours under oath about why the military is spending way too much on a certain ingredient, that is just checking.
Completely valid.
Yeah.
Congress is monitoring how their recipe is being interpreted, but the constitutional violation, the usurping, that happens if Congress tries to, stand in the kitchen.
Yeah, walk right in.
Right. They walk in, grab the spoon out of the chef's hand, and start directing them on exactly how much salt to add to the pot at that exact moment.
Which they cannot do.
No. Once the law is passed, the power of execution belongs entirely to the executive branch. Congress cannot retain direct control over how a law is carried out day to day.
And the bar exam materials highlight a very specific and surprisingly common, honestly, way Congress tries to grab that spoon. It's this device called the legislative veto.
Yes. The infamous legislative veto.
And to a layperson, it actually sounds incredibly efficient.
It does.
Like, let's say Congress passes a massive environmental statute. They might write a provision in the law that basically says, if the EPA creates a specific regulation we don't like, a simple committee in the Senate can just hold a quick vote to nullify that regulation.
And it sounds wonderfully efficient. I mean, why go through the grueling, agonizing process of passing a whole new law just to tweak one little agency rule?
Right. Why not just have a quick committee vote?
Because that is exactly why it is unconstitutional. The legal framework requires what we call bicameralism and presentment.
Meaning a law has to pass both the House and the Senate, that's the bicameral part, and then be presented to the president for a signature or a veto.
Exactly. The framers of the Constitution, they intentionally made passing a law an exhausting, friction-filled nightmare.
It wasn't an accident.
Not at all. They wanted it to be incredibly difficult to alter the legal landscape because that friction prevents knee-jerk tyranny.
It slows everything down.
Right. So when Congress tries to use a shortcut, like a one-house veto or a committee resolution, to cancel an executive action, they are bypassing that protective friction.
So if they want to change the legal consequences of an EPA regulation, they can't just take a shortcut.
No, they have to do the hard work of writing, debating, passing, and presenting a brand new law.
You can't just shout from the dining room that the soup is too hot and expect the kitchen to magically change it.
Yeah.
You have to write and publish a whole new recipe. And the sources point out that Congress doesn't just try to change the recipe, they also try to control the actual people cooking it.
Oh, absolutely. Appointment and removal powers are huge battlegrounds for this. Congress can create an enforcement agency, right? And they can define the duties of the people working there.
Right.
But they generally cannot appoint the head of that agency themselves. And they definitely cannot keep that agency head under their direct removal control.
Because if Congress can fire the chef at will, the chef isn't really working for the president anymore.
Right. They are essentially working for Congress.
Which means Congress has successfully retained the power of execution for itself.
Yes. And that is the textbook definition of usurping.
So if Congress is constantly trying to micromanage the kitchen, we obviously have to look at the flip side.
Of the president.
Right. What happens when the president decides to cook something completely different? Or, even better, locks the kitchen door and refuses to let anyone see the ingredients?
Yeah, now the dynamic completely flips. It's not Congress overstepping anymore. Now it's the president pushing the boundaries.
And the masterclass script relies really heavily here on one of the most famous legal frameworks in American history, right? The Youngstown framework.
Yes, Youngstown, Sheet and Tube, Covey, Sawyer. When a president takes an action that creates tension with Congress, the courts evaluate the president's power by placing it into one of three distinct zones.
I see this constantly in the news when executive orders get challenged. They always talk about category 1, 2, and 3.
So category 1 is the president acting with Congress's express blessing or authorization. This is the zenith of presidential power.
The absolute peak.
Exactly. Imagine Congress passes a law specifically authorizing the president to impose trade sanctions on countries that violate certain agreements. And then the president goes ahead and imposes those sanctions.
Both political branches are completely aligned.
Right. The action is almost bulletproof in court.
The recipe says make a cake, the chef makes a cake, and everyone eats.
Perfect. Category 2 is where it gets a bit murky. The sources actually call this the twilight zone.
The twilight zone, that sounds ominous.
It is, legally speaking. The twilight zone happens when Congress is completely silent on an issue. They haven't authorized the president's action, but they haven't explicitly forbidden it either.
Okay, so like a gray area.
Yeah. Let's say the president takes a novel foreign policy action that just isn't addressed in any statute. The power here doesn't rely on clear rules. It relies heavily on historical practice.
So the courts look at what past presidents have done.
Exactly. Has Congress historically looked the other way when presidents do this kind of thing? Or is this a sudden, massive power grab? It requires a very fact-intensive analysis by the courts.
But the real fireworks happen in Category 3.
Oh, yes.
Because this is the absolute weakest position for the president. This is when the president acts against the express will of Congress.
Right. Let's use the procurement hypothetical from the source material. Say Congress passes a statute requiring all federal agencies to use a very specific, totally transparent bidding process to buy new equipment.
Okay.
But then the president issues an executive order telling agencies to just ignore that statute and use a totally different closed-door process instead.
So the chef decides to cook a steak when the recipe explicitly called for a vegan salad.
Exactly. And the president's fundamental constitutional duty is to execute the law, not to rewrite it. An executive order simply cannot override a validly enacted statute.
So in Category 3, the president's action is almost certainly going to get struck down.
Almost certainly, yes.
Which naturally leads us to the next massive conflict. If Congress can't micromanage the kitchen, their ultimate oversight tool is demanding to see the receipts, right? They issue a subpoena.
Right.
But then the president refuses to hand over the documents, claiming executive privilege. This collision, the president versus the courts, is arguably the most dramatic part of the whole system.
And it's important to note, executive privilege is a real constitutional doctrine. It is not just some made-up political shield.
Okay.
The courts actually recognize that a president requires a certain level of absolute confidentiality, especially for sensitive matters of national security, but also just to get candid, unvarnished advice from top advisors.
Right, but I'm going to push back on the sources here for a second.
Okay, go for it.
Because they keep emphasizing that this privilege is qualified and not absolute.
Yes, qualified privilege.
But think about it. If I'm a top-level advisor to the president, and I know my candid, potentially embarrassing advice could eventually be dragged into a courtroom and projected on a screen just because the privilege is only qualified, I'm going to censor myself.
Right.
Doesn't the very fact that a court can pierce this privilege defeat the entire purpose of having it in the first place? Like, it inherently chills the advice the president receives.
It absolutely chills the advice, and the courts fully acknowledge that reality. Governing is messy, and people speak differently when they know they might be recorded.
Exactly.
But we have to look at the terrifying alternative. If executive privilege were completely absolute, the president would be entirely insulated from the judicial process.
Oh, like completely untouchable.
Exactly. They would effectively be a king operating this shadow government that is totally immune to any legal scrutiny. So the system demands a balancing act. It balances the president's need for secrecy against the judiciary's fundamental duty to resolve actual cases.
And the sources point specifically to criminal proceedings as the arena where that balance aggressively tips away from the president.
Yeah, because in a criminal prosecution, the justice system's need for evidence is at its absolute peak. I mean, you cannot run a fair trial without facts.
Right.
So if a federal court issues a subpoena for documents that are directly relevant and necessary to resolve a pending criminal case, the court will weigh that urgent need against the president's claim of privilege.
And who usually wins that?
Almost universally in criminal settings, the judicial need wins. The president will be forced to produce the documents.
But doesn't that risk spilling national secrets in open court?
Well, often they submit them for the judge to review privately in their chambers first. It's a process known as in-camera review. That ensures sensitive secrets aren't needlessly spilled to the public.
Okay, so let's test the limits of this with the overreach hypothetical from the DAR material.
Let's do it.
Imagine a scenario where a president issues a blanket directive granting absolute immunity to all current and former executive branch officials from all congressional and judicial subpoenas.
Wow, okay.
Right. Just throwing a giant impenetrable shield over the entire branch and basically saying, nobody talks, ever.
Yeah, that is the literal definition of usurping the judicial role. A blanket refusal covering all officials, all communications, and all topics that is totally inconsistent with the qualified nature of the privilege.
So they can't just wave a magic wand.
No. The president cannot simply issue a decree declaring total immunity from inquiry. Claims of executive privilege have to be evaluated on a case-by-case, document-by-document basis.
Okay, so if the courts have the ultimate power to pierce executive privilege and force the president to hand over evidence, who keeps the courts in check?
That is a great question.
Because right now it sounds like the federal judges basically hold all the cards.
Well, Congress actually holds the leash on the courts. And they do it through these really sweeping structural legislative power.
Really?
Yeah, it's actually shocking how much control Congress has over the federal judiciary when they choose to use it. For one, Congress creates all the inferior federal courts.
Meaning everything below the Supreme Court.
Right. And they define what types of cases those courts are even allowed to hear, which is called defining their jurisdiction. And most importantly, Congress can change the substantive law that the courts are forced to apply.
The sources mention Congress can actually change the law right in the middle of an ongoing lawsuit.
They can.
Which is wild to me. Like, if I'm a plaintiff spending millions of dollars suing a company over an environmental regulation, and halfway through the trial, Congress passes a brand new statute changing the underlying environmental standard.
The court just has to apply the new law.
They don't have a choice.
They absolutely must apply the new law.
Really?
The court's job is to apply the law as it exists at the time of their decision. Congress legislating a new standard is just Congress doing its core job. It's valid checking.
But there has to be a line, right? If Congress can just rewrite the rules mid-game, where do they cross over into usurping judicial power?
There is a line. The Masterclass script outlines 3 very specific uncrossable limits for Congress here.
Okay, let's go through them.
Limit number 1, Congress cannot direct the outcome of a specific pending case under the old law.
What does that mean exactly?
They cannot pass a statute that says, in the case of Smith v. United States, currently pending in the federal appellate court, the court shall enter judgment for the United States.
Okay, let me put this in sports terms.
I love the analogies today.
Congress is the rulemaker, right? So they can absolutely change the dimensions of the strike zone right in the middle of a baseball game.
Yes.
The umpire just has to adapt and use the new strike zone for the rest of the innings.
Valid checking.
But Congress cannot pause the game, march onto the field, and tell the umpire, you must call this specific pitch against this specific batter a strike.
Exactly the right framing. Changing the strike zone alters the overarching law. That is a legislative act. But dictating the call on a specific pitch directs the outcome of a specific controversy.
And that usurps the umpire's job.
Right. It usurps the judge's core function.
Which brings us to the second limit.
Yeah.
If they can't direct the outcome of a game currently being played, I assume they definitely cannot go back and change the score of a game that was played last year.
You've just deduced the rule against reopening final judgments. Congress absolutely cannot reopen a final Article III judgment once all appeals are exhausted.
And just to clarify for everyone listening, when we say Article III judgments, we are talking about rulings made by the federal judiciary created under Article III of the Constitution.
Right. So your federal district judges, appellate judges, and the Supreme Court.
Okay.
So let's say a plaintiff wins a complex civil case, gets a judgment for damages, and the Supreme Court eventually affirms it. The legal process is over.
It's done.
Done. Congress cannot subsequently pass a statute purporting to reopen that specific judgment just to reverse the award.
Because then the courts wouldn't really matter.
Exactly. If Congress could just pass a law reversing any final court decision they disagreed with, the courts wouldn't be a co-equal branch of government. Their rulings would just be advisory suggestions waiting for legislative approval.
It would destroy the concept of an independent judiciary.
Completely.
It makes total sense. I mean, you can't have a functioning legal system if the losing party can just go lobby Congress for a legislative mulligan.
Right. And the third limit seems geared entirely toward protecting the judges themselves on a personal level.
Oh, how so?
Congress cannot reduce the salaries of Article III judges during their time in office.
Ah, which prevents financial blackmail.
Exactly.
So if a specific federal court goes on a streak of striking down Congress's favorite laws, Congress might be tempted to pass a targeted, say, 30% pay cut for those specific judges just to punish them.
And the Constitution specifically protects judicial compensation to prevent exactly that kind of retaliation. If judges were terrified of having their livelihoods slashed every time they ruled against the government, they wouldn't be impartial umpires.
No, they'd be terrified.
They would be constantly checking the political winds before writing a ruling.
Okay, so up to this point in the deep dive, we have been looking at these constitutional battles in very neat one-on-one scenarios.
Or clinical scenarios.
Yeah. Congress versus the president versus the courts, Congress versus the courts. But if you watch the news for more than 5 minutes, you know the real world is infinitely messier.
Oh, yeah.
Often, all three branches get into this sprawling, chaotic brawl at the exact same time. So how is a listener supposed to untangle a three-branch pileup without needing a law degree?
Well, the bar exam script offers a brilliant, honestly very practical simplification method for exactly this. When you are faced with a massive constitutional mess, don't panic.
Step 1, don't panic. Always step 1. Step 2, you simply reduce the three-way fight into bilateral, two-sided pairs. You break the chaos down into its component relationships.
Okay, let's walk through the specific nightmare hypothetical the sources use to illustrate this.
Let's do it.
Here's the setup. Congress passes a very clear, unambiguous statute.
Okay.
The president signs the statute, but immediately issues an executive order interpreting the law in a way that completely contradicts the plain text of the statute.
Okay, classic conflict.
Then, a regulated business gets hit by this contradicting executive order, so they sue the administration in federal court. And in the courtroom, the administration's lawyers demand that the judge simply step back and defer to the president's interpretation of the law.
It sounds like an unsolvable knot of power grabs, doesn't it?
It sounds like a headache.
But apply the simplification method. Break it down pair by pair. Let's look first at Congress versus the president.
Okay, so Congress wrote a clear law. The president is actively contradicting it with an executive order. Which means we plug that relationship straight into the Youngstown framework we talked about earlier. The president is acting against the express will of Congress.
So that is category 3.
Exactly. Category 3. It is the absolute weakest position for executive power because the president cannot rewrite a validly enacted statute. So in that specific pairing, Congress's statute easily defeats the executive order.
Okay, so Congress wins that round. Now we take the second pairing, the president versus the courts.
Right. The administration is telling the federal judge to just defer to the executive branch's interpretation.
And to resolve this pair, we go all the way back to the bedrock of American law, the case of Marbury v. Madison.
Yes. It is emphatically the province and duty of the judicial department to say what the law is.
The courts possess the power of judicial review.
Exactly. They do not run executive policy, but they are the ultimate arbiters of legality. The judge will look at the clear statute, look at the contradicting executive order, realize the president is in Youngstown Category 3, and the court will enforce the statute.
But when you break it down into these bilateral pairs, is there always one dominant conflict that dictates the entire outcome? Or do you essentially have to keep a scorecard of every mini-fight to see who ultimately wins by points?
Usually, one dominant constitutional violation drives the entire resolution.
Okay.
In this hypothetical, the dominant fact is that the president is violating a clear statute. Once you isolate that Youngstown Category 3 violation using the bilateral breakdown, the court's role becomes incredibly obvious. The method just helps you strip away the noise and the political posturing to find the core structural failure.
So if you're listening right now, you essentially have the cheat sheet for how the U.S. government operates.
You really do.
You have the structural map. The master rule to remember is checking is allowed, usurping is not. Congress can oversee the kitchen and change the recipes, but they cannot execute the law or hold the chef's spoon.
Right. And the president executes the law and enjoys immense power, but they cannot rewrite statutes against the will of Congress.
And the courts review the legality of actions, but they don't run day-to-day policy. And Congress writes the laws, but they absolutely cannot dictate specific judicial outcomes or reopen closed cases.
It is an incredibly empowering way to consume information, honestly.
It really is.
Next time a massive, jargon-filled Supreme Court ruling drops, or a chaotic news story breaks about the branches clashing over subpoenas or executive orders, you don't have to feel overwhelmed by all the legal speak.
You can just ask yourself, who is trying to do someone else's job right now?
Exactly. You are seeing the underlying matrix of the legal system.
But before we wrap up, I want to leave you with a final provocative thought, something that bubbles right beneath the surface of all these rules and hypotheticals we've covered today.
Okay, I'm intrigued.
This entire constitutional system, this intricate, cutthroat board game of checks and balances we've been talking about, it relies on one massive, fundamental assumption about human nature.
That is true.
It assumes that each branch will jealously guard its own power to keep the others in check. It assumes Congress will always fight to protect the power of Congress, and the president will fight to protect the presidency.
Yeah, the founders banked entirely on institutional ambition, counteracting institutional ambition. They believed human nature would make the people in each branch fiercely protective of their own turf.
But what happens to this carefully balanced machinery if modern political party loyalty eventually becomes stronger than a branch's desire to protect its own institutional power?
Oh, wow. That is the question, isn't it?
Right. What if a Congress stops checking a president's massive overreach simply because they happen to belong to the same political party?
Or what if they hypercheck a president to the point of total paralysis just because they are in the opposing party?
Exactly. Will the historical patterns of separation of powers we just outlined still hold? Or does the board game fundamentally break down when the players care more about their team color than the piece they're actually moving?
That is a fascinating way to look at it.
It is definitely something to keep in mind the next time you see the players reaching across the board.